Tim Hortons is facing a $500,000 lawsuit after a customer says she suffered second-degree burns from spilled tea that was too hot. She blamed the restaurant for negligence, saying scalding temperatures and the condition of the cup created a hazard. But the company denies any wrongdoing. Talia Ricci has the story, but first a warning, this story contains graphic images of burned skin.
It's tough.
Jackie Lansing says all she did was pick up her cup of Tim Hortons tea from her car's cup holder when the cup collapsed, spilling the scalding hot liquid all over her.
Of course, you start to scream because it hurts. I picked it up normally. I didn't try and take off the top or anything. I just picked it up.
This happened back in May. She was with her sister at the time, who drove her to the hospital in Huntsville.
I was in there for about 5 hours with ice packs on it and on morphine because it was so painful. They were open wounds, bleeding.
It would be the first of many more visits to the hospital after suffering second-degree burns to approximately 6% of her body. For a period of time, she was going daily to get her bandages changed. One of the wounds got infected. Lansing says after Tim Hortons' head office didn't get back to her, her family encouraged her to get a lawyer. They're suing for $500,000 in damages. Tim Hortons declined to comment while the matter is before the courts. The defendants, the Tim Hortons Canadian franchisor and the owner of the location, deny any allegations of negligence. The statement of defense argues the defendants, their agents and staff fulfilled all duties of care in regards to the sale and delivery of hot beverages, and that even if the spill was a result of the condition of the cup, it was not in any way caused or contributed to by any breach of care or duty on the part of the defendants. This lawyer, who's not involved in the case, says lawsuits against restaurants claiming damages for hot beverage burns are common.
As long as you're able to prove that something was done out of the ordinary, that there was some negligence here, then you should be successful in a case like this. But there are always risks, right? And one thing that I always warn every one of my clients or potential clients about is the risk of contributory negligence on the plaintiff.
Lansing says 10 months later, she still has sore red scars on her stomach, and the back of her legs are sensitive to sunlight and heat. This doctor says he sees cases of burns and scalds from hot water often.
And I think awareness of prevention strategies for companies businesses serving hot fluids, and also to just for everybody to be aware of first aid, that's important. You could avoid long-term effects by just applying that.
Lansing hopes sharing her story provokes change.
The water does not have to be that hot. It doesn't. I don't want this to happen to anyone else.
Talia Ricci, CBC News, Toronto.
We're now joined by Rajiv Haté, who you heard there from in that piece for a more in-depth talk. He is a personal injury and disability lawyer with Kotak Personal Injury Law. And thank you for taking the time, Rajiv. So you talked a little bit about it, but just very simply, what's the likelihood for success with this lawsuit?
Yeah, and thank you so much for having me, Andrew. Really, it's very fact-specific in these situations because it really depends on what exactly caused this spill to occur. There's a number of circumstances that are going to have to be looked into, including what kind of cup was used, what's the appropriate packaging for this kind of beverage that was being served, what was the temperature of the water that was in the tea that was served, and was that an appropriate temperature based on sort of industry standards, and a way to sort of look at that is compare what other establishments sell hot beverages at in terms of what temperatures they're at. So, the likelihood of success does depend on all of those factors in a case like this.
So what happens if the case goes to trial, or are these cases usually settled before that?
The majority of lawsuits are settled before a trial. But what happens if it does go to trial? It's likely going to require some expert testimony here, in my opinion, because when the allegation is that it's the cup itself that collapsed sort of in and on itself, the question is, how could that happen? And you may need an expert to comment on that, right? That it would only collapse if the liquid in there was a certain temperature, for example, or again, what would cause cause a cup of this material to deteriorate in such a fashion? And then, of course, another factor that's always looked into, as I had mentioned previously, is there any potential contributory negligence on the plaintiff? Is there anything she did to cause or contribute to the spill, or is there anything she could have done to avoid it, right? And again, that's the sort of unknown. It's likely going to take a discovery process and likely some experts to comment on exactly what took place, how it took place, or how something like this could have possibly occurred.
Now, the lawyer representing the family argued that Tim Hortons hasn't taken sufficient preventative action following similar scalding incidents, including one involving a Winnipeg woman in 2013 who suffered third-degree burns. So how could that affect this lawsuit?
Yeah, if there's a history of knowledge of the fact that, for example, the beverage is served at too hot of a temperature and they don't do anything to rectify the situation, knowing that it is a danger and a hazard, that definitely can amount to negligence against the Tim Hortons for not taking steps to rectify that hazard and that condition. And, if I was the plaintiff's lawyer, I'd likely be arguing the same thing, given that there is a history of this. And so that is definitely something that could come into play if we're able to prove that the temperatures have not changed and that the temperatures that they were served at are not appropriate for the beverage that's being served.
Now, the defense, of course, is asking for the case to be dismissed. Is that a possibility with this case?
So, every statement of defense I've ever received in my office always asks for a case to be dismissed. So I'd say that's fairly boilerplate. Whether or not a case will be dismissed, it really comes down to, is there a triable issue of fact? As long as there is a triable issue, then it will not be dismissed, for example, just in a summary judgment motion where a judge wouldn't just say a judge alone couldn't decide if a case like that could be dismissed. If there's an issue in terms of what is the correct facts and what took place, that's something that will be left for likely a jury to decide. I'm assuming there's likely a jury notice filed in this case.
Rajiv, thank you. Rajiv Haté, a personal injury and disability lawyer with Kotak Personal Injury Law, joining us from Oakville, Ontario.